Welcome everyone. My name is Andreoni. I'm an associate professor here. I'm convening this IIPP Research Seminar Series. Welcome. This is the first event we are organizing for this second term. This is a fortnight series that we run at the Institute. I see people still joining the room. We've just started. Tonight we have great pleasure to start this term with a colleague from the University of Oxford, from the Blavatsky School of Government, and with us is Beatriz Kira, who is a senior research associate there. Beatriz is a lawyer by background and social scientist, and she has been graduating from the University of Sao Paulo with a PhD in economic law and political economy, and also an MSc in social science of the internet from the University of Oxford, where she is based now. Over the years, she has been working extensively on competition regulatory issues in the particular digital technology, digital platform space. And this is actually what also she will be discussing tonight. She also has experience in the real world, in the world of competition authorities and regulatory agencies across the world, in particular from Brazil, where she is from. Thanks, Beatriz, for accepting our invitation. It's a great pleasure to have you here. As usual, we will be recording this event. We will have a up to 45 minutes presentation from Bea, and that will be followed by a reply from Professor Kattel, also from our IIPP, and then we will open the floor for Q&A. I invite people throughout the event to put your question in the chat or to raise your hand, and I will welcome you in the panel for asking your question directly to our speaker tonight. So without further ado, Beatriz, the floor is yours, and thanks again for being with us tonight, and thanks everyone for joining.
Thank you so much, Antonio, Professor Andreoni, for the invitation, for the opportunity to be here and present my ongoing research with you and the people attending the seminar tonight. And of course, thank you for Professor Kattel for being the discussant here. I'm really very much looking forward to the comments. Just in terms of introduction, the research I'm presenting today is a piece of work I have been conducting with a colleague, Paulo Tejano, who is currently based in the Philippines, and I think it's quite late there, so he's not able to join us. But this is part of a wider research agenda on the global economic governance of the digital economy that we are conducting here at the Blavatsky School of Government in Oxford. And the idea behind this piece of work is that as digital technologies become increasingly more pervasive, the question of how to regulate them effectively cuts across sectors and affects all large firms, but it also crosses across borders. So the digital economy has, in fact, joined nations closer together in a way, and governments around the world have been realizing that the management of new and existing technologies are still far from optimal, that they need somehow to update their legal toolbox to be more fit for purpose in the digital age. And in this seminar, I want to focus on one of particular, maybe a couple of tools in the legal toolbox. One is competition law, and the other is economic regulation. It could be seen as an umbrella, or it could see as a pair of instruments that should be used to regulate those markets. And in this presentation, I would briefly start with a backdrop, presenting the backdrop against which I developed our analysis and the evidence that has been led scholars, regulators, and policymakers from different jurisdictions to become more worried about the concentration in digital markets. I will then show that these concerns are shared by different nations, but governments have so far acted independently when designing and implementing policy solutions. And the argument that we make in the paper is that while this patchwork approach has some merit and can indeed be explained in light of political economic considerations, there are also gains that could be made through a more coordinated international approach. And to support this argument, I will discuss in more detail 3 buckets of problems that emerge from digital markets, highlighting the international dimension in the cases. So one of these buckets is the use of antitrust to punish anti-competitive behavior by dominant firms. firms that have significant market power. The second bucket is the review of mergers and acquisitions in order to prevent transactions or concentrations that could have an adverse effect on competition. And then the third bucket are focused on novel competitive regulatory frameworks that have been proposed aimed at addressing the structural and systemic concentrations in digital markets. And the discussion will be based on the analysis of specific antitrust cases and proposed regulations that are a bit more broad, examining their actual and potential cross-border effects. And after arguing in favor of a more coordinated international approach, what we do in the paper is to discuss some of the challenges that would need to be considered for any implementation of this approach. And we focus mainly in two types of challenges. First, institutional challenges, and second, political economy challenges, considering the perspectives of developing countries and also smaller nations, so outside some of the big examples that we're going to give here. Then finally, I will end the presentation with a discussion of some of the preliminary conclusions that emerged from this study. And I'll be really keen to hear from you, really, how we can make the best use of the findings that we have so far and that we aim to gather in the future. Because our goal with this research is to produce both an academic paper, but also to deliver some policy-oriented output. And I think the audience in the room and the comments that Professor Kattel will present could really help to highlight where this could be most valuable, this study. So that's it in terms of the structure, and I hope you can end today with a good grasp of what are the cross-border dimensions of competition in digital markets. And I would like to start the presentation with a little bit of background on the dynamics of competition in digital markets and the evidence that has been published about it so far. And I will do that, but I'll ask for apologies to those in the room who are already very familiar with some of the concepts and some of the data that we'll present. I think for the competition and antitrust experts in the room, this might be a little bit repetitive, but for the benefit of the people who are not really competition scholars, lawyers, or economists, I think a little bit of contextualization might be helpful. And what the data shows is that in the last decades or so, there has been a global trend towards greater corporate concentration, including from medicines to manufacturing, and at least in developed countries where there's more data to analyze. And according to economists, the calculations by the economists, for example, in the US, 2/3 of 900 and something sectors covered in the US economic census became more concentrated between 1997 and 2012. This trend is also true in all the OECD nations, with, for example, in the UK, the four biggest British firms have accounted for a larger share of the revenue in 2018 than a decade earlier. And I think in over 50% of 500 sectors that were surveyed, there's been an increase in concentration. The same trend is also true in the EU, although it has been a little bit more slowly. And the academic literature has been interpreting this data and show that also the increase in concentration has been more dramatic in digital markets or markets that are intensive in the use of technology. And this increase has been pushed by some superstar firms. And indeed, we are seeing a small number of major digital platforms becoming very dominant in online markets and extending these dominant positions into new markets, complements or adjacent markets, creating really extensive digital ecosystems. And this has brought renewed concerns that these firms are losing the ability to innovate and are involved in practices that are harmful to consumers, and also to innovation. There is increasing evidence from academics that the growth in concentration has been at least partially related to a lax or unfit use of competition policy and regulation. So academics from different backgrounds have been arguing that existing legal tools to promote competition have been too slow or unfit, and the resulting remedies are largely unable to tackle the highly dynamic digital markets. These remedies are mostly based on static measures and not really able to cope with the dynamic nature of digital markets. And there's also growing concern that the fact that antitrust interventions are very one time only make them unable to deal with structural and systemic problems effectively. So competition law and competition policy is really a bit more suitable to deal with specific conducts or one specific merger at a time, not really with the systemic and structural problems that the data has shown. And drawing on this evidence, we are now seeing a revival of competition policy, not only within policymakers, but also in academia, as I've been saying. And governments around the world have been realizing that a new approach to digital competition is needed, one which permits more flexible and responsive action to avoid harms, to benefit consumers, and to foster innovation. And some of the tenets, the core tenets of competition law, such as the idea of consumer welfare and some of the analytical tools like the definition of the relevant market or the notion of market power, have now been revisited. They are now under review. And for example, in the EU, the competition commissioner, Margaret Vestager, has been arguing for the need of a broader notion of consumer harm. So not a very narrow, efficient-based notion of consumer harm. And economists have also been proposing new ways of identifying harm in digital platforms or in platform markets. They're not really using the previous instruments within the competition law toolkit. So for example, Professor Mariana Mazzucato and researchers here at the IIPP, including Professor Rainer Kattel, have proposed an alternative way of measuring harm using new measures of value creation and value extraction in the notion of rent. At the same time, on the other side of the pond, President Joe Biden has appointed the senior antitrust roles in his administration, scholars that are also very vocal critics of the growing power of big tech companies. So we can see Lina Kern now chairs the Federal Trade Commission, and Qing Wu is the White House advisor on technology and competition. So really this more proactive and critical approach to antitrust has to some extent becoming mainstream. And this is to say that while there is a lot of action going on in different parts of the world, especially, and the focus here is in the UK, US, and the EU, regulatory action has been somehow fragmented. So even though the largest technology companies have a global footprint, and the competition problems that emerge from the digital economy are mostly shared by different nations, the attempts to regulate them are so far very fragmented and unilateral. Action from government has been very unilateral. And the differences in illegal and political frameworks across jurisdictions really make an absolute uniformity unfeasible. And the idea here is not that I'm arguing that all the frameworks and the legislation should somehow converge into a unified global competition regime. That wouldn't be feasible and even not desirable. But our study departs from the assumption that it is important to understand the international dimension of the problem and to further explore whether and how a greater level of coordination could lead and contribute to more effective public policy in this area. And again, there are various sources of value creation and value distribution across these multi-sided and multi-layered digital markets. And they spread really across the borders of a single nation. So it's understandably that the hypothesis, the part here, is that from an enforcement perspective, greater coordination could reduce aggregate costs and the length of individual investigations. Also, from a substantive perspective, our hypothesis is that cooperation could reduce externalities and increase the effectiveness of regulation, both for users and for firms, improving the quality of services and fostering innovation. We also think, and we do mention that in the paper, that users could benefit to some extent from a more consistent approach and clarity regarding what really are the rules of the game, depending on what apps they're using or where they're based in the jurisdictions, really what some greater level of predictability and legal certainty in order to use the services, but also for business to conduct business. In our analysis, we have identified, as I mentioned before, 3 broad areas where we see this relevant international dimension. And I'm going to discuss each of them now individually and provide examples of cases where we found relevant cross-border effects that we think are worth considering when judging similar cases. So just before discussing the details of our analysis, I just wanted to add a quick note on methodology here. And you see from the discussion that the cases we included in the analysis are ongoing investigations, decisions, already finished decisions by competition authorities, and some proposed regulatory regimes. So, and the targets that they have are usually big multinational technology firms and the online services provided by them. And here, the disclaimer is that we did not attempt to map all decisions or all cases or to cover all big tech firms, but rather to focus on illustrative examples where we find that this cross-border nature is more relevant. Again, we also chose to focus on big tech cases because these are the ones where we believe the cross-border effects are most acute. And the examples are also very much focused on the United States, the European Union, and the United Kingdom. Not only because they have been the nations, the jurisdiction in the forefront of some of the debates and decisions, but also because their decisions are more likely to influence, and we know it's already happening, influence the decision-making in other jurisdictions. And we do recognize that this is a very Western-centered approach, and we are missing a considerable chunk of the digital economy, mostly because we are not including the analysis at this point, China and the cases that have been more recently tackled in China. So we do recognize that in the last 12 months or so, China has been cracking down on tech giants as well, shifting towards tougher rules and enforcement, and they're also blocking mergers and imposing heavy fines. However, considering that the Chinese digital market has remained relatively disconnected from the global digital economy, and that the biggest Chinese players don't have the same global footprint as the US companies, we did not include them directly in the analysis of the cases. But we could maybe perhaps consider doing that in a later stage. But our analysis, however, does include considerations of political economic challenges that include China. And lastly, in terms of methodology, I just wanted to mention that while the bulk of the work so far has been based on desk research, we are going to conduct elite interviews with some authorities, complement and add nuance to our analysis. So that's something that is also ongoing from our side. Great, so finishing the quite of a long methodological note, going to the findings of the cross-border challenges, and the first bucket of challenges is focused on anti-competitive behavior and the international dimension of recent attempts by different nations to enforce competition law and to punish and remedy anti-competitive practice in digital markets. And again, for those of you who are not very familiar with competition law and policy, that's a quintessential distinction within competition law between the focusing behavior and focusing concentration emerge in a way. So this first bucket includes the behavior and nature problems related to the behavior of companies. And what I would like to highlight is that the task of using competition law, or at least the traditional conventional instruments and steps of analysis within competition law to curb anti-competitive practice is substantially more challenging in these digital markets. And not only because there are new types of anti-competitive behavior could emerge from these markets, but also because it's more difficult to identify using the conventional antitrust methodology, for instance, considerations of price and of whether or not there is being increasing price due to the behavior, are really not suitable to the dynamics of digital markets. And these new practice or new behaviors that really don't fit in the traditional boxes of anti-competitive behavior include, for example, considerations of exploitative data practices or algorithm collusion. So when independent of human intervention, different machines or like algorithms can agree on the price or in a way that prevents users from seeing it, how it happens. And what I also mentioned is that the interconnected nature of these digital platforms also are more challenging because of because it gives rise to digital ecosystems. And this means that there are more ways, more pathways and incentives for firms to pursue certain strategies and some types of behavior that could lead to anti-competitive outcomes. For example, enabling the discrimination of competitors through self-preferencing practice, so giving preference to their own products and discriminate against the products or the services of competitors. And indeed, because again, many of these largest firms have integrated across different business lines and control key infrastructures, they're really intermediating and setting the rules, orchestrating these entire ecosystems and the relationships within those ecosystems. And what we do in our analysis of the case is to focus on cases involving 3 companies and mapping the international dimension of previous decisions on anti-competitive behavior involving Google, Amazon, and Apple. And in the Google bucket, we include 2 flagship cases: the Google shopping case and the Google Android case. And in the interest of time, I will only present our analysis on the Google case, or the Google cases rather, but I'll be very happy to delve into the other cases in the Q&A and the discussion. Okay, so the Google cases. These have been 2 of the most important and relevant and well-known antitrust cases related to anti-competitive behavior and big tech firms, maybe in recent years. And these cases were filed by the European Union, so the European Commission, against Google. The first that was investigated and subsequently found, and Google subsequently found guilty, was an investigation by the European Commission of violation to Article 102 of the TFEU. And the rule there was that Google was considered guilty of favoring its own online shopping comparison tool, so Google Shopping, in its search engine results. So discriminating against competitors who had their entries downgraded in Google searches results, while Google's own shopping tool was ranking higher. And this decision also came back to the headlines recently because it was so they upheld the decision. And then the second case, the Android case, was when the European Commission found that Google used illegal tying practices, such as conditioning the licensing of its products, so forcing mobile device hardware manufacturers to pre-install Google apps, such as Google Search and Google Chrome, in order to have access to the Play Store, which also Google controls because it owns Android, the operating systems for mobile phones. So apart from the fines that Google had to bear, I think was 2.4 billion in the first case and 4.3, I think, in the second case, billion euros, which, and again, that's considering that that was a few years apart from the decisions. Google was also required by the Commission to comply with certain remedies that were designated to correct the anti-competitive effects of the behavior in the affected markets. And the use of the term remedy here in competition law, I first found it a bit odd, like as if the market was ill, but the idea is to correct something that the competition authority thought should be fixed in the market. So a remedy to fix competition in the market. And in the Google Shopping case, Google complied with the requirements, the remedy, to bring to an end its anti-competitive practice of favoring Google Shopping and operating Google Shopping as a separate business entity in Europe. So it was a behavioral remedy because it required Google to separate how it operates the business practice. So it didn't really ask Google to sell its Google Shopping platform, but really there's a lot of evidence saying that it wasn't very effective in how it really favored all the search engines to show their products on Google. And then in the second case, Android case, Google responded by allowing European Android users to select their preferred browser and search engines when they start to use the Play Store. So giving really the choice to consumers of whether or not to use the app, the Google apps, or to choose for a different browser and a different search engine. So all these brief summaries of the case is to say that while these proceedings were carried out by the European Commission and then the European courts, and they have been deeply scrutinized and discussed, and there's really a lot of literature and cases and people commenting on these cases, the analysis of the legal and economic effects of the decision have been squarely focused on the domestic European market. And what we do in our analysis is to try to go beyond and explore the facts that the EU decisions have had or would have had in other jurisdictions. And these include how Google's business practice in other countries might have been affected by the EU decision, or meaning whether or not Google felt like it needed to adjust its practice beyond the European market. Also, whether or not there have been effects on users of Google Shopping services and of Android users outside the EU. So really the effect on people using the app, has there been any friction in terms of using the apps in different countries. And then thirdly, the ripple effects that these decisions had on other competition authorities and other regulatory agencies. So how other regulators outside the EU have perceived the EU decisions and what effect they had internationally. So to begin with, what we found is that Google does not operate its shopping services similar across different countries. The evidence that we were able to find show that the compliance with the separation of Google Shopping Europe from the generation of results in its search services have been really focused on the EU market. And even in that case, it's not really clear how it works there and whether it's been effective. As such, that it might have been missed opportunities for other jurisdictions where such practice could also be deemed anti-competitive to really react against of the decision. So what really happened, and I think that links to our third point here, is that rather than having a single decision change a practice that could benefit more consumers, different jurisdictions actually started similar cases. So the European Google Shopping case was maybe the trigger to a series of other legal cases that required a lot of time, a lot of money, and a lot of effort to, in many cases, reach the same conclusions. In some cases, and Brazil is one of them, and it was a very outcome is different. So the Brazilian Competition Authority did not find Google, did not find that Google was engaged in anti-competitive practice, mostly because it couldn't find evidence of the effects of the practice in the Brazilian market. So just to say that the EU decision did not change the practice of Google in other countries, but it did trigger a wave of Google shopping cases in different jurisdictions, in some cases with similar outcomes, in some cases different outcomes, but we didn't find evidence of a substantive exchange of information and exchange of learnings between the authorities in these cases, even though when you look at decisions, again, for example, from Brazil, they mention and they make reference to the Google case and the European arguments in the rationale of the decision. And then we also examined the argument that acting unilaterally, the EU remedy was not as effective as it could have been. So again, numerous pieces of commentary work have argued that the desired outcome of the European Commission have in fact not been achieved because Google's compliance with the decision really did not meet the requirements of the imposed remedy. I think the hit was more in terms of the fine rather than in terms of really adjusting the conduct. So if it didn't adjust effectively for the European market and it had really limited effects beyond the EU. Similarly, in the case of the remedies of the Android, there is a choice for users in the EU, but if you're outside the EU or have not been is not in a jurisdiction where similar cases have been initiated, the effects of the decision really does not cross borders, even though the product is the same and the competition risks that could emerge are potentially the same. So the point here is to illustrate that there could be international coordination in these cases, in particular, could act in the benefit of less resourced nations, and with the sharing of evidence and information gathering the investigations, mostly by the EU Commission, which has a lot of resources and people engaged, and also sharing intelligence in the design of remedies, not saying that necessarily the same remedy would have to be applied in a jurisdiction, but really sharing intelligence, best practice, and the evidence that was gathered could be helpful, in particular to smaller nations that don't have the same resources as the EU. Great. So this was our analysis of the first bucket of issues. And I'm now moving to the second bucket of issues, which focuses on merger review. And the concern related to merger review in digital markets is that the concentration in digital markets that has been observed across the economy has been even more dramatic in markets involving technology companies, in that this is partially due to overly lenient or overly lax merger policy globally, leading to excessive concentration in digital markets. And you can see this graph that is published in a work by Elena Gentesi and others, showing really the practice of big tech companies of really increasingly buying potential competitors and smaller companies, and leading to greater concentration in these markets. And this is relevant because merger control is one of the key existing mechanisms for supervising and shaping the structure of digital markets. So if you look at law as a tool to shape and to really orchestrate markets, there is evidence that it's not working very well in the case of mergers and acquisitions in digital markets. They have faced very little scrutiny in the past. And the literature has pointed out that the criteria and the thresholds that are commonly adopted in order to decide which cases should be subjected to mandatory pre-merger notification, that is, cases where the company should go to the competition authority and file a notification, have missed relevant transactions. So the criteria is not fit for purpose. So there might have been an under-enforcement of merger control rules there. And even when the cases are reviewed, there are structural features in digital markets that create challenges for substantive merger review. So conventional tools used to identify the mergers, for example, based on tests that are based on prices, are unable to cope with the challenges of mergers in these markets. And in response, nations have been considering different merger policy rules, so new rules, and revisiting concentrations that have already taken place. So looking back at mergers that happened before to see if they are problematic and then try to fix them. And this is an area that we find there is a lot of potential to discuss the cross-border effects. And indeed, the cross-border nature of multi-jurisdictional mergers in general, not only focus on digital markets, is a contentious topic. And there have been cases in the past outside technology companies that have caused that have attracted a lot of attention. So in terms of pharmaceutical companies, or even in the agribusiness companies that are multinational, they file cases of, they notify the mergers in different jurisdictions. In the difference in results really affect the possibility of the deal going ahead. So for example, one risk that we identify is that the decision in one jurisdiction of banning the merger could frequently lead to all the parties abandoning the merger completely. So if a merger was filed in countries A, B, and C, even if A, B approved the merger, if either propose remedies or prohibit the merger of going ahead, this decision could have effects in A and B, and it could be the case that it won't go ahead. Or even if A, B, and C decide to impose remedies to the merger, the fact that they might act unilaterally means that 3 different types of remedies might not be reconciliated, and that could lose the effectiveness in regulating the concentration. And in the paper, we discuss the international dimension of these problems in light of 2 cases involving Facebook. The first being the the recent CMA decision to undo the takeover GIFI, the GIF database company. And we also consider the FTC suits that seek to break up Meta of Facebook, names confusing, into Instagram and WhatsApp. So we break up big tech, and whether there is grounds for that in the US. So just being conscious of time, rather than going to the nitty-gritty details of what are the dimensions of diversity or breaking up that could have a negative effect, say that in none of the decisions that we analyzed, the spillover effect or the effect of the diversity in other nations have been considered. And this is particularly concerning in terms of the US, where most of these companies are based, and the decision to break up some companies in the US, decision either to break up or not to break up actually could have really big effects all over the world, because these companies, although they're based in the US, they are really active in many different countries. And to be fair, in some cases, the biggest user base of the product is not even the US. So I think in the US, the WhatsApp, 20% of the population use WhatsApp, whereas in countries like Brazil, in India, is like a much bigger proportion. I would say 60%, but I might be making up the percentage. I need to check the value, but it's much, much more. So just moving into the next bucket, the third and final group of competition issues that we analyzed in the paper include more general concerns with systemic and structural concentration in technology markets. So this is different from our discussion in merger review, because not necessarily these higher levels of concentration come from mergers and acquisitions. They all don't come from mergers and acquisitions that have been subject to merger control. So what we're trying to see here, and the focus of analysis really, are on the proposed new pro-competitive regimes that some nations have proposed to tackle this structural concentration and the specific dynamics of big tech companies. And I should say these rules are all ex ante rules, so they apply before the fact, differently from competition law enforcement, which usually takes place after the fact. These would be rules setting rule books that would apply ex ante before, from the beginning, to technology companies that will fall within the scope of the proposed legislation. And our analysis in the paper focuses on 3 distinct regulatory proposals that aim to tackle the market power of digital platforms. So these are the bills proposed in the US, several bills. In the EU is the DMA, the Digital Markets Act. In the UK is the DMU, Digital Markets Unit, which is part of the CMA, the Competition Markets Authority. And we consider them in terms of, because they're the more mature proposals that are out there, they are also very detailed in terms of the rules that they include. However, we do recognize there have been other attempts in other countries. For example, in South Africa, I think there is a law that just passed that prohibit, that tackle concentration in app stores, and specifically in terms of monopoly payments. So allow companies to use different payment systems within the app stores, which is similar to the Epic Apple case that we do discuss in the paper, but I didn't have time to discuss here. And just in terms of the overall findings of our comparative analysis of the EU DMA, the US bills, and the UK GMU, is that all these proposals, they share the goal of establishing a regulatory framework that would lead to more effective and speedy outcomes than traditional competition law would be able to. And they also take into consideration the particularities of digital markets. So the fact that they are structured as ecosystems, there is some kind of vertical but also horizontal integration in a way that is different from traditional brick and mortar markets. But what I would say is that rather than going to all the 4 bullet points I've listed in these slides, which is the criteria to identify the firms, the specific obligations that apply to them, and the role of the regulator and the remedies, I should say that although the scope and the purpose of these regimes are very similar, there are some substantive differences between them that could create some kind of friction, and that could argue in favor of greater coherence and greater collaboration between the authorities in the enforcement. And just maybe to illustrate these differences, and the differences are often related to the wider regulatory framework that are in the places. So for example, in the case of the EU, the Commission, which is a huge, well-staffed body, has a lot of discretion and has the authority, according to the proposed regulations, to interpret and give some kind of granular details of the regulation. While in the US, really, the regulation is aimed at the courts. So who is going to enforce the regulations are the US courts, and not really the regulator has a very limited scope. While in the UK, there is even a higher degree of flexibility and discretion to the regulator, because in the case of the UK, the proposed regime would be a bespoke kind of system where different companies would be subjected to different rules according to their characteristics. Just so some headlines, differences between the 3 regimes. And what we really wanted to focus, and we do that in more details in the paper, is to say that there is considerable level of convergence, but there is enough difference and enough divergence between the proposals that could lead to friction and could perhaps justify some level of coordination in designing remedies and adopting specific obligations for big tech companies. And with that, I finish the 3 buckets of challenges that we discuss in the paper. And then just briefly, being conscious of time, go over the last 2 points of the presentation. One being that, again, while we realize that there is an argument for cooperation, we do discuss some challenges to implement this greater level of international cooperation. And although governments have started to recognize the benefits of working together, international conversations so far have been quite limited and really focus on an old rationale of establishing an MOU and starting to talk and, oh, let's share some information and maybe some technical capacity building. But now, in terms of the characteristics of digital markets, we have seen more recently some action towards more close cooperation. In April 2021, the Australian, UK, and German competition regulators published a joint statement on merger control enforcement, highlighting the importance of agencies to collaborate for rigorous and effective merger enforcement. So mentioning the word enforcement there in terms of cooperation, which is an advancement. And we also argue in the paper that any form of existing cooperation beyond exchanging information might need to face institutional challenges and political economy challenges. And briefly, in terms of the institutional challenges, we see that there isn't yet international multilateral institution with teeth that will be able to really coordinate and promote this substantive level of convergency. And in the absence of this body, what's happening is that other networks or international organizations might be stepping up, maybe more to promote conversations and dialogues rather than really designing rules that would be effective across the borders. And I'll just mention that the OECD, the ICN, and UNCTAD are some of these bodies where conversations towards more procedural coordination have been taking place. And then finally, in terms of political economy challenges, they are really non-trivial. And even if there was some type of institution that would have the capacity and the political buy-in to actually coordinate around the topic of market competition, the revived interest in competition policy has been coupled with some escalating geopolitical rivalry. So there is a lot of discussions on how the new regulatory regimes that aim at promoting competition are also maybe leading to arms race in terms of technological arms race, and have been curtailing the US ability to preserve its rightful place in the global economy. And in the US, this is a very powerful argument, the concern that these new regimes could hurt US companies in the race against China, and also that the EU would be targeting US companies somehow unfairly. And it's interesting to see that the US bill that was recently approved in the Senate was amended to include the possibility of covering Chinese technology companies such as Tencent and TikTok, and clarifying that groups should not be forced to hand in data to all the technology company that has been sanctioned by the US government. So really including some kind of national security concerns into the bill that aimed at fostering competition. And then there's also efforts of the EU and the US they have announced a Trade and Technology Council, which has one of the purposes to counter China's rising influence and to establish some new global standards for emerging technology. So the China issue is very sticky in terms of cooperation in digital competition because of the many possibilities that regulating digital markets bring. And then briefly, because if I'm not mistaken, I'm already out of time, I just wanted to say that we are still digesting the findings and coming up with conclusions and recommendations, but our provisional conclusion is that more substantive international cooperation and even more effective procedural international cooperation could indeed remove some of the frictions that we found in your analysis of the instruments, but coherence of approaches would not always be feasible or not even desirable. While from a purely economic perspective, eliminating negative externalities might be good and might reduce unwanted outcomes, from a legal perspective and from a political economic perspective, there are some costs that are worth bearing in order to uphold democratic rights and values, and even just to fit with the wider legal framework of particular jurisdictions. So this should be taken into consideration. We're not saying that countries should cooperate at all costs. And then maybe where there is likely to be value where engaging conversations about the international dimension would be relevant. We just think that this should actually happen. So really not ignore the international dimension of many of the cases that have just been discussed, because this is what that has been happening so far. We don't think that necessarily would change the outcome, the final outcome, but really just shedding light that these problems are not really only domestic, and that any decision and regulation in this space is necessarily going to have some cross-border effect, and this cross-border effect might be more felt more strongly in developing countries, in countries that don't have the capacity and the resources to engage with them, or even to implement some of the regulatory solutions, is worth bearing in mind. And that's the end of my presentation.
Thanks so much. Thanks so much. This was brilliant. And I think what fascinates me in particular is, it opens an entire research agenda, because, of course, if the decisions taken from this competition authority are also depending on the relationship between the impact of this digital platform, different type of economic structure in this part of the world, clearly you have lots of heterogeneity, right, in terms of what the outcome of these, the same type of decisions from the competition authority can make lots of sense in European context, maybe not make any sense in any other of the jurisdictions that you are looking at. And also, of course, this sort of new industrial policy that has been emerging, right, under these usual disguised forms, right, in terms of how, by regulating markets and sort of finding an alignment of interest between the West against the emerging largest ICT companies like Huawei and others in this space, is becoming part of that reinforcing of a new polarization that, of course, goes on the opposite direction of, I think, your main argument, actually more coordination. So thanks so much for that. It was brilliant. I think, Rainer, it's up to you now for a set of structured comments, and I keep inviting people. I see some questions already coming up to prepare yourself for the session.
Right. Yeah, thanks. Yeah. Thanks so much for this very interesting presentation. And yeah, I have I think like 4 or 5 sort of questions, comments maybe, because yeah, I think there are more comments, but I think it would be good to hear your sort of thinking about them as well. So I think I think it's like there's like really great value in sort of trying to document how competition authorities are dealing with this digital economy challenge. I think in that sense, the research area, the paper, I think it's like very valuable knowledge that comes out of that. I think and really interesting discussion. And what I was wondering is, you talk about these 3 different types of behavior essentially by digital competition authorities: anti-competitive behavior, mergers, and pro-competitive activities. But I don't think you talk too much what sort of is driving those behaviors. Is there a wider political agenda, political economy, or maybe theoretical, who knows, sort of arguments behind it? So I was wondering whether that could be like a useful layer to add to the analysis. And that sort of led me to think, are we actually seeing like an emergence of, because what you're doing, you're sort of trying to go from nation state to international, but it seemed to me there is something actually in between, which maybe not so much regional, but there is almost like international sort of, competing regimes partially emerging that are not only, because European Union, for instance, is not one country, right? So it's like a European Union has to deal with, Germany and Malta both at the same time, and they're like very different, economies, if you will. So whether we're actually seeing something like a competition policy regime emerging, like, you talked about China very recently, sort of starting to crack down on digital platforms. US has very different kind of motivation behind it, has to maybe to do much more with the political environment, and the European Union has its probably from its actually treaties the focus on, because the constitutional sort of environment, if you were in the European Union, that the focus is on consumer markets. So because this is what European Union sort of jurisdiction can deal with. And whether that actually leads to this emergence of competing regimes, And this might be like a quite interesting, maybe an additional sort of layer there, because then you can again start asking what is driving those different regimes, what they're actually looking for, like what are the sort of the framework and conceptual arguments, because in some cases you can argue this has to do with security. Some cases it's sort of the old sort of maybe in Chinese case you can even argue there's this core periphery dominance actually that they're looking for to increase in the Asian region with their approach to digital economy. And and in some cases I think European Union is very strongly sort of driven by this market failure, consumer behavior logic rather than much else. Also, even in the European Union, you can argue there's like almost like competing logics of industrial policy and the sort of the envy of not having digital giants. And then if you look at policy and especially competition authorities, they're actually sort of still stuck in the sort of market failure and consumer behavior rather than taking then the wider approach. So I think there's something interesting in this middle layer of sort of international political economy that's emerging around digital space, and you can see partially, I guess, even in the sort of the G20 tax regulations that probably targeted very much the digital companies, but that didn't probably lead to much eventually because they are just too smart probably to have that. So yeah, so this was my first set of questions, or sort of I was thinking whether this in like the concept of competition policy regimes might be actually interesting to deploy here. And the other sort of set of comments or questions is around this whether competition policy actually is the tool, the most potent tool that governments can use in sort of digital economy discussions, and actually in the sense that whether competition policy is the sort of the right tool for anti-competitive, dealing with anti-competitive behavior in digital space. And that has to do with, partially the arguments by Bill Lazonik and Tim O'Reilly that really focus on corporate governance rather than competitive behavior. They sort of argue that the way that particularly the US corporations are set up, that the reporting is set up, and the financialization of sort of the CEO payments and the buybacks and all the sort of the building up of the blitzscaling, the idea that you have to have an enormous sort of financial backing in digital economy without actually having to have profits and things like that. So I think their sort of logic would lead to competition policy is not actually that relevant anymore. You actually have to tackle corporate governance and logics, and so I'm not sure whether this is right or wrong, but I think it could be again another like an interesting layer to see whether any of those competition authorities are actually engaging with this kind of corporate governance. And you can even argue that taxation issues are maybe around the same logic. And maybe it's that you need to have combination, competition policy, corporate governance, all of those. And so that might be another interesting set of issues. And third set of questions I had is because a lot of the companies you mentioned, and Google particularly, of course, are not just digital companies, but they are increasingly also sort of the future of the digital, right? So if you look at the research, for instance, in artificial intelligence, Google is already the leading global institution. So no country can actually compete with Google's output in artificial intelligence, basic research. So it's not all innovation, but it's also actually basic fundamental science. And so you have this like an increasing polarization in the future of technology, digital technology, where, on the one hand, you have US and China that can actually invest and compete as countries and as companies, and on the other hand is the rest of the world. So whether there is, and that sort of leads me back to the sort of competition policy regimes, where actually US and China actually don't really care about their domestic markets, but they care about global sort of dominance and being pitted against each other. And so it's a lot of more like a political discussion, I think, around technology. And I think that you'll probably find that a lot in the sort of artificial intelligence discussions. And similarly, I think there is this entire sort of opaqueness of a lot of the future technology in terms of smart contracts, blockchain, that by necessity or by definition is not accessible to any competition authority. I mean, that's the definition of those technologies, right? That you can't, even if you can access, you can't regulate it. you have to just sort of essentially, it's like alcohol, you prohibit that or you let it go. And so I think that leads me again to this kind of whether question how much sort of this current competition authority behavior in digital space is actually reflecting also the future fears, if you will, of having an increasingly polarized world and where two big centers of digital markets, US and China, are actually essentially sort of creating international rules, and where those rules are very much driven by actually global dominance and security and politics and things like that, rather than any of the innovation and all that. So these were just thoughts. As I said, I mean, I'm not sure you have to address those questions, but I think there's, they lead to your presentation led me to think these thoughts. Thank you so much.
Thanks so much, Rainer. This is a very rich set of remarks and opens to a broad discussion. I would suggest, Bear, if you think it's a good idea, because we have a bit of time also to think through, let's pick up some questions and we can come back to these three set of issues around different competition regimes, which you very much hinted in your presentation, even not explicitly as a regime, but actually there is a regulatory regime that makes them this intermediate level of coordination. What is the competition policy, industrial policy, corporate governance, all these interface, and of course the last remarks about the new areas, including of course digital trade and all these issues around how the regulation will evolve in that space. So we can go back to all these issues. So I have already two hands raised. I would suggest we take these two and feel free to plug in further comments and reflection of what also Rainer has just said while you go through all of them. I'm sure Rainer points were broad enough to be picked up by further questions. So let me try to see if I'm good enough now in doing, so there is a comment by Anna Binotto. Let me try to promote her to panelists. Let's see if it works. Usually works, but if not, and the other one is from Fausto. Okay, yeah, Fausto is in, and Anna is in. Fantastic. Anna first, and then Fausto, please.
Hi, do you listen to me and see me well?
We can.
So, Beatriz, I'm Anna. I'm a PhD candidate at the University of São Paulo. I'm a former colleague of Beatriz's. Thank you so much for your presentation. I really enjoyed it. And I was curious about your interpretation of the different decisions of the Google shopping cases. Especially, you've mentioned the decision adopted by the Brazilian authority not to convict Google here for ultimately what could be considered similar conduct as the one that was ultimately sanctioned by the EU authorities. So I was curious, you've mentioned that you found that the conduct and application function wasn't exactly the same in the two countries, or at least in different countries. But I was curious to know if you have found elements or additional elements that could justify those different decisions, those rather incoherent, one may say, decisions, such as, for example, a different maturity of the debate of competition in digital platforms here in Brazil, for example, or a different proneness of the authority to overall sanction multinational companies and especially big tech companies, a larger political economy reason behind that, or maybe one could say different resources and capacity by CAGE of Brazilian watchdog. So I was just curious about additional findings.
Yeah, that's great. And it goes back to these differences across regimes, capacity, regulatory frameworks that might drive these differences. Fausto, and then we go back to Ben.
Can you hear me?
Yes, we can.
Thank you very much, Beatriz. It was very interesting to hear your presentation. Competition policy is is the focus of my own research, so I felt that these issues were very close to me. I'm a PhD student at IIPP. So the question that I wanted to ask you is, a general reflection on the harmonization of legal regimes. In the second half of the 20th century, we had this harmonizing trend in trade-related issues. This might have had many positive results. However, in a way, it also led to two types of problems. On the one hand, it led to certain interests being prioritized over others. You know, the interests of certain countries being prioritized over the others. And as a second issue, it reduced the policy freedom of countries to experiment in issues, for example, related to intellectual property regulation. And this had like a big impact also in terms of development for many countries. Like, don't you think that more coordination in competition policy enforcement would lead to similar problems? In a way, the geopolitical issues that you raised are a subset of this question, right? Because geopolitics would reflect the interest of certain countries over the others, which is a big issue in competition policy. Like, for example, the AT&T monopoly in the US was tolerated for a long time, given its close connection to the US military. So yeah, antitrust enforcement always does have the sort of a strategic motive in certain countries.
That's great.
Yeah.
Thanks a lot. Now I'm just conscious of time as well, so you time to bear, because these are quite substantial set of questions. So please bear. That allows you to go back also to respond.
Thank you. Thank you so much. It's been such a rich set of comments and questions, and really made me reflect. And I think it would be helpful incorporating some of the reflections in the next iteration of the paper. And also just to say that the benefit of answering a set of questions, a round of questions, that I might not answer all of them. So if please, I forget something or a piece of them, hold me to account, and I'll make sure that I'll go back to your point. But maybe in order, and in terms of the wider political economy considerations that could be behind this renewed interest in antitrust and this maybe new industrial competition policy, I think there are some drivers, and I think that relates again to the competition regimes and the intermediate layers, but there are also more similarities than maybe differences. I think that across the different regimes that have been identified, EU, US, and China, they do share some underlying concern that big tech companies have become too big and too powerful. Of course, that the roots of these concerns are somehow different. Again, the crackdown on big tech in China has been partially caused by concern that the state was kind of losing grips with the size of those companies, whereas in the US, for example, there is some kind of concern that the size and power of these companies have been economic power of these companies have been translating into political power and have been causing an imbalance in democratic values of the US, whereas in the EU, there is also an interest in fostering domestic champions in a way, and creating an industry of technology companies that have been flourishing more in the US, sorry. So I think, again, there are different underlying reasons, but the overarching theme is big tech companies are too big and too powerful, and they have been somehow competing with the states at different levels and competing with power against states. And I should say that my own perspective to competition law, and I think that is something that is relevant to answer Fausto's question as well, is that a law is a perspective on law and political economy. So law really as a tool to shape markets according to specific and not always clear political views or objectives. And I think that it's naive to say that competition law is blind to politics. It might be not necessarily a translation of party political politics, but there are political values that guide the design of competition policies throughout different periods of time. And I think this is very true in terms of the US, how the US competition regime has evolved over time, when with its roots, there's this debate in terms of the roots of the US competition law were to tackle concentrations, really to burst the trust at the time. And there has been a reinterpretation of the objectives of American antitrust policy to serve some interests that were more pervasive in the second half of the 20th century. And now some people are arguing that we are seeing a shift back to this Brundisian approach to antitrust in the US. So again, there are very clear political trends that really give competition policy some flavor and some orientation in a way that really translates into the practice of agencies. And putting the mix, Anna's question here in terms of what could have been the reasons that led similar conduct, similar behavior to be considered not unlawful by the Brazilian authority. I would say that the level of maturity of the authority at the time in terms of the knowing really the risks and the problems and the functioning of digital markets could be one, but I also think that some kind of political leaning of some sort, again, not party political, but in terms of political economy, could have also played a role in the outcome of the decision. And again, that is not to say that it is necessarily a problem per se, because in a democratic society, one would expect that the people in those positions, having been appointed by democratic elected candidates, would be reflecting the values of the society. But again, there is some flavor to the decisions and to the enforcement practice that led by politics. And the role of law is not to be oblivious to the relationship between economics and politics, but really to be a link between the two of them. So yeah, that was a long answer, but I agree that maybe including the intermediate layer and discussing regimes and different kind of drivers could be relevant. And maybe I would add to the three regimes that were mentioned, like the US, EU, China, a fourth maybe cluster of countries would be the small developing countries that really don't have the same clout and space and expertise or even technical capacity that some of the other ones have, but they're somehow really affected by the decisions, and maybe Brazil would be added to the bundle as well. So I think thinking of this intermediate layer and what is driving enforcement practice and really lawmaking in different parts of the world could be a really good layer, interesting to add to the paper. Then moving to the question in terms of, is competition law the best tool to tackle many of the problems regarding concentration that I discussed? I wouldn't say it's the best. I would say that is one of the tools, is an important tool, but I think that maybe a Swiss Army knife approach to concentration could be the way forward, whereas it wouldn't be an either or in terms of either competition law and policy or more effective corporate governance or new rules regarding conflict of interest, but rather a combination of some rules and some instruments of public law combined with maybe new rules of private law as well. I mean, private law is not necessarily my area of original expertise. I'm more of a public law type of lawyer. Economic regulation, competition law are the tools that I have been working with in the past, but I do recognize that they are imperfect tools, and even though there have been proposals to make them more effective, they could be blunt in many situations. So for sure, some private law, corporate governance could be helpful there. Yeah, I think the question on future-proofing competition law and blockchain to address blockchain and AI is the most difficult one. I think the short answer would be, I don't know, but I think a more evolved or developed answer would be that governments are always going to be catching up with technology in a way. And I think it requires a new way of thinking regulation and thinking about how to govern technologies that is not the traditional policy making, traditional rule making, and maybe some kind of co-regulation or co-development of rules with the companies rather than trying to be something top-down could be more effective, especially for these new technologies that are emerging and are really going to emerge in the future and you don't really know well. But yeah, I think that's a tough one. And just moving to Fausto's questions on the harmonization of legal regimes and the risks that there are, and there are many. And I really try to make a balanced presentation, recognizing that I'm not arguing for coherence necessarily or harmonization. I think that's, I'm familiar with some of the problems that previous attempts, not only in competition law, but as you mentioned in trade and intellectual property have created. So the choice of word coordination, maybe of sharing information and sharing more detailed analysis of the cases, I think that could be beneficial rather than prejudicial to small and developing countries. And I agree with you that there is the risk that with greater coordination could be somehow of colonization of the regulatory regimes that could lead to unwanted outcomes. But maybe the benefits of engaging more and learning from the experiences of authorities with more resources and more technical capacity could be beneficial to developing countries, being aware and being conscious of the risks that exist. But again, I don't think that harmonization would be the way forward, and quite the opposite could lead to some of the problems that we've seen in the past. But also using the cluster kind of framework and thinking very careful about what is the best type of coordination involving the cluster of developing smaller nations could also serve a purpose in terms of the framework and analysis that we're doing here. So I think that's also helpful to think about the risks as well.
Thanks, Bea. Thanks. I think also it's interesting how, for those who are interested also in more developing countries or middle-income countries perspective, Bea was involved in coordinating the Oxford initiative of digital pathways to prosperity, where myself and some other people have been also collaborating, also from IIPP. So there is quite a lot of interesting perspective around this issue around coordination, right, and mindset of competition authorities, right? Because in a sense, lots of the problems we are describing were the same that in a pre-non-digital, but more still monopoly capitalism type of situation, authorities were trying to address already in the 80s and 90s, with of course the other rise in multinational corporations that were using, of course, and facing other type of regulatory boundaries in terms of international trade regulation. So there is a sort of rediscovering some principle, right? Like, the kind of work that Alice Amsden and Ajit Singh were doing on takeovers, and you show some of this issue and optimal competition and how you implement this coordination of policies from an industrial strategy perspective, not just from a purely market regulatory perspective. And on the other end, this problem of what is the mindset, right? And is the changing the mindset sufficient in countries where, as you said, the key point is the enforcement is not simply so transparency to a certain extent of sharing data presupposed that then there is capacity to enforce, right? But we know that, as you pointed out, these authorities are themselves part of a political economy setting where the willingness to enforce certain type of practices not necessarily will be followed. I don't see other questions coming up. I just like to open and give a chance for people if they would like to raise another round. Thanks, Faust, and thanks, Anna, for very interesting perspective and comments. And of course, thanks, Rainer, for providing all that set of issues. I don't see anyone else, so I think we can move towards the end. Thanks again to everyone to take part in the discussion today. We're going to be back in a couple of weeks' time with another seminar. We will move towards green finance with Professor Ulrich Boltz from SOAS University of London and Katie Kedward from IIPP, who is going commenting the piece. So follow us on our website. Thanks again, Bea, for excellent presentation. Thanks, Rainer. Thanks, everyone.
Thank you. Thank you so much.